Okay, we're here again. It's Atlanta Discuss. Every Friday, we come out with a topic that interests the world. I know some of you accused me, I got some mails recently that, why are you always talking about Nigeria? And I always respond that Nigeria is the largest concentration of Black people on the planet. It's really, really acting behind schedule. And a lot of people are disappointed. The great Madiba, like I mentioned in the past, once said that if Nigeria gets its act right, the entire African continent will get its act right. Africa as a continent today is not doing very well. Even those we expected so much from the southern part of Africa are not even living up to the billing. I've heard people say if Namibia, if Zimbabwe and South Africa were still under white rule, they will be doing far better. We can't even argue with that because when you compare what's been happening, you really, you will be surprised. Now we've had so many countries still going back to the military. We've seen what happened in Niger, Guinea, Mali, and they're forming a new alliance that could probably break the bones of the founding fathers, especially in the ECOWAS sub-region. And most importantly, our elections, they used to be free and not fair. Now they're not free, they're not fair. Now to compound it all, our judicial system is in comatose in almost every nation in the continent. I mean, you really, really, really need to think hard to count 5 countries in Africa that the judiciary works with. That's why today we're going to talk about the Malabo Protocol and the state of the criminal justice system in the continent of Africa. And I've said in the past, I don't know anybody else. I think I read a lot, but I do not know anybody that have said so much, that have written as much as Professor Anselm Chidi Odinkalu, who is our guest today. Professor Odinkalu, welcome to Atlanta Discuss.
Thanks a lot, Ade, for having me.
What I was trying to say, I don't know anybody that's written as much as you have on the judiciary, especially in Nigeria and Africa. So in our tradition, we always go for the jugular and go straight to the point. So, Prof, Malabo Protocol, what's it really about? We've heard it as passing, we read it in books, but nobody really understands, especially from people like us, layman point of view, what's really all about the Malabo. I know Malabo is the capital of Equatorial Guinea.
Well,
And I
yeah,
know protocol, it's a means of getting things on certain way. So what's the Malabo protocol?
it's interesting you should start that way because that's actually how I start whenever I talk about Malabo Protocol. And thank you for actually having a conversation on this, by the way.
Yes, sir.
Um, because I start with a geography lesson, which is Malabo is the capital of Equatorial Guinea. That's where the conversation always begins. And it is the place that in 2014, African heads of state in the African Union adopted a treaty to create effectively a criminal jurisdiction or a court, endow a court with criminal jurisdiction to try international crimes in Africa. Now, a protocol, now having said that Malabo is the capital of Equatorial Guinea, where something happened in 2014, a protocol is actually a form of treaty. A protocol is a treaty that amends or supplements a pre-existing treaty. In this case, what transpired was this. In 1998, the Organization of African Unity, as it then was, created an African Court on Human and People's Rights, which is a continental court to deal with human rights violations in Africa, state responsibility for human rights violations in Africa. That court currently exists. It actually functions out of Arusha in Tanzania. Then in the year 2000, the African Union ceased to exist and it was succeeded by the African Union. 3 years later, in 2003, the African Union created a Court of Justice of the African Union. So you would ask me, what is the difference between an African Court on Human and People's Rights and an African Court of a Court of Justice of the African Union, and why should there be 2 courts? Technically speaking, the Court of Justice is supposed to deal with issues affecting regional integration and trade in Africa, and also disputes within the African Union. And the African Court of Human Rights is supposed to deal with human rights issues. However, the African heads of state, indeed, as a matter of fact, in 2004, when President Obasanjo was the chairperson of the African Union's head of states, he believed that it was not necessary for us to have these two separate costs. It was going to be very confusing and indeed costly. And so he suggested, why don't we merge them? So in 2008, the African Union merged the two courts into one institution with two different sections, a regional integration section, a general issues section, and a human rights section. The Malabo Protocol took that further in 2014 by making it one court with three sections, not two. So under the Malabo Protocol, this continental court will now have three different sections: a human rights section, a general issues section to deal with trade integration and all of that, and an international criminal law section to deal with international crimes. And so that broadly speaking is what it is. Under the Malabo Protocol, Africa will now have a continental court to try international crimes in Africa. That would be war crimes, crimes against humanity, genocide, trafficking in persons, trafficking in toxic substances, trafficking in drugs, corruption, unconstitutional changes in government, aggression, and crimes like that. In all, there are 14 crimes covered by the Malabo Protocol.
Interesting. Wow. Now, if it's a protocol, the way I understand it, under AU, most of the countries have to be signatories to it. Do we have all the 54 countries in Africa signing on to abide by whatever the protocol says?
Not at the moment. And that's why the protocol is not yet in force. Oh. The protocol requires that it will come into force when 15 African countries have ratified it. And ratification is a formal act by which the head of state or president or prime minister of a country formally signifies that they would like to be bound by the treaty and would like to be participants to the treaty. At the moment, one country alone has ratified, that's Angola. 15 other countries have signed but have not yet ratified the treaty. So we are now in the process of going from country to country, preparing them and then engaging them for the purpose of ratifying the treaty, the protocol, that's the Malabo Protocol. And it's very important, as you well know, we now have in existence in The Hague, the International Criminal Court. And the International Criminal Court has jurisdiction over what are called the four core international crimes: war crimes, crimes against humanity, genocide, and aggression. For the most part, though, there are three problems with the International Criminal Court. One is that its budget is limited. For next year, I believe the budget of the court is about 200 million euros. I think 202 million euros to be more exact. The problem with that is that you can't, with 202 million euros, you can't cover the world. You can't cover most of the crimes in the world. So that's one. Number two is that given that the ICC has to make choices, and most of the choices the ICC has made have been focused on African countries. That has created challenges. Of course, people will say, oh, recently the ICC has moved on. It has arrest warrants out now in relation to the war in Ukraine, particularly for the president of Russia. It's currently investigating Palestine, and the possibility of arrest warrants for the prime minister of Israel is there. That's also another issue. But most people will tell you that whatever happens, the likelihood of ever rendering those people for trial that's as in the president of Russia, the prime minister of Israel, is next to is at zero or somewhere around there. And in any case, depending on the outcome of the next US elections next month, if the ICC issued an arrest warrant for the Prime Minister of Israel, you're going to have high octane politics of, around that. And the last time the ICC tried to investigate Afghanistan, the United States imposed sanctions on the prosecutor of the ICC and some senior staff of the ICC, who, by the way, were Africans. So this focus on Africa has led to the third issue, which is the perception that the justice of the ICC is racialized, right? And because of that, of these three factors, what's happened, there is a concern, therefore, that it is important, given Africa's situation, for the continent to take charge of some, at least, of these crimes. And what's happened with the Malabo Protocol is that in addition to the 4 core international crimes, the continent has added 10 other crimes to the jurisdiction, the scope of the jurisdiction of the Malabo Protocol, or the court to be created under the Malabo Protocol, to reflect challenges that are specific to the African continent. For instance, the challenge of coups, unconstitutional changes in government, is certainly one that is very specific to Africa. The trafficking in hazardous wastes and trafficking in persons. Africans who are being shifted from a lot of equatorial countries across the Sahel towards the Mediterranean, for instance, and there are criminal gangs involved in that. Now, how do we ensure a jurisdiction, an effective jurisdiction for interdicting those kinds of things? So you'd like to think that there is actually a mutuality of interest here between those who are interested in addressing illegal migration on the one hand, and the African continent in trying to address the establishment of a jurisdiction to address that kind of thing. So those are the issues that are covered by the Malabo Protocol.
Interesting. Yeah, let me just ask you this: What fifth? I know Angola has really signed it and it's official. But what are the 15 countries that have signed but not ratified? And when you say ratification, if let's say the minister or an ambassador signs for the country, ratification in this regard, does it mean that the Senate or the Congress or whatever of that country has to ratify?
Now, ratification is governed by the constitutional systems of different countries. Yeah. In some countries, ratification is an exclusively executive act, so the president does it. In other countries, it requires parliamentary authorization. So parliament votes to authorize the president or prime minister to ratify. That is the Angolan system. The Nigerian system, for instance, is that the president ratification is exclusively executive. Now, to understand ratification, it's probably useful to go back to the history of the origins of treaty systems generally.
Please go ahead.
Historically, treaties are negotiated between sovereigns, between heads of state or between countries. And so a head of state would send, or a president or a king or queen would send their representatives to another place where a treaty is negotiated. And for that purpose, they will authorize somebody to go and negotiate the treaty on their behalf. What usually happens, however, in those days was they traveled by water, by sea, and it took some time. And they got there, they did what they needed to do, and at the end of the agreement, once an agreement was negotiated, the person authorized on behalf of the king or queen would sign to say, we have agreed. But that does not necessarily bind the king or queen, because you've got to go back, present the document you have agreed to the king or queen. The person will review it or have it reviewed on their behalf to confirm that what you have returned with conforms to the instructions they gave you when you left. So there is a time lag between the authentication of the text as what was negotiated and the indication by the confirmation by the sovereign that this negotiated text reflects what I asked for, and therefore I am willing to be bound by it. That time lag is the difference between signature and ratification. So signature authenticates the text as what was agreed. Ratification And that signature can be done by any representative authorized by the king or queen or president or prime minister or head of government, howsoever called. Ratification can only be done by the sovereign, either the president or the foreign minister. And that says we have authenticated this text as reflective of what we negotiated, and we now subscribe to be bound by it. That requires a constitutional authorization or conformity with the constitutional standards for that purpose. In Angola and Senegal, as I have said, for just to cite two examples, Parliament authorizes that process. In Nigeria, the president can do that or authorize the foreign minister to do that on behalf of the president.
So what are the 15 countries that are signed in Africa?
I'll have to, I don't want to make a mistake about that, but
Okay,
you know, I can get that for you before we are done with this.
No problem.
Yeah.
Okay, let's move on to something else. I mean, we all know what the Malabo Protocol is all about, what it entails, and what is expected of it. And I didn't want to ask you that, but we all have an idea of why it's probably lagging behind because based on most of these crimes, I mean, more than half of the presidents in the continent are probably, so they won't want it to be ratified. So do you think a system, a completely different system of democracy should be created for African countries? Because President Obasanjo recently was saying that Africa should look for a democratic system that is in consonance or that can work for it, that the way the Westerners bring it, be it parliamentary or presidential, may not necessarily work for us because of our clannish system, tribal issues, and so on and so forth, and possibly maybe our authoritarian way of doing it. Do you think we should, as a continent, evolve a system that works for us?
Now, the question is, what exactly is democracy? You
Mm.
know, I mean, I did read President Obasanjo on what he said. It's also the case that he did not offer
The solution.
anything on what the new model should be. Um, Now, there is no single model to begin with of democracy in Africa or around the world, right? And it's actually arguable that no two models of government, even in the African continent, are the same. You know, um, for instance, if you look at Africa, there are only what four federations in Africa: Nigeria, Ethiopia, Sudan, and South Sudan, right?
Yes, correct.
South Africa is a hybrid, um, but mostly unitary. Kenya is parliamentary presidentialism.
Mm.
Senegal has a president and a very powerful prime minister. Cameroon, you tell me what Cameroon is. You've got Rwanda, you've got Uganda, what is Somalia? Look at Egypt, look at the monarchies of Morocco and Swaziland. And Lesotho has a monarchy, by the way, but it's not an absolute monarchy. So we've got a whole slew of systems across the continent. Just to begin with, there is no homogeneity. Now, so what is the problem? It's actually, there is nothing like about democracy that makes it difficult for Africa to digest. It is simply that heads of state have failed to conform to the rules that they agreed to. Nothing else. And by the way, to get back to your question and address the question before returning to this issue of the African countries that have signed the Malabo Protocol, you've got Benin, Chad, Comoros, Congo Brazzaville has as well. Equatorial Guinea, obviously, because that is the country in which it was adopted. Ghana, Guinea-Bissau, Guinea, Kenya all have signed it. Mozambique has signed. Mauritania as well. Sierra Leone, Sao Tome, and Togo have all signed, as well as Uganda. So there are 15 countries that have signed it. But Angola is the only one that has ratified. I just wanted to be exact so that I don't provide information here that is not factually accurate. This is a list provided by the African Union. Now, so returning to the question of African countries and African models of democracy, frankly, I don't know where these people are. Basic history. Look at our kingdoms of old, African kingdoms. You know, from the country that you and I come from. Yep. Now, if you look at the kingdoms of the Oyo Empire, for instance, right? And the system of the Oyo Empire, any of the Yoruba states, as a matter of fact, the Ijebu, the Ijesha, but old Oyo Empire, for instance. Now, could you say that it did not have legitimacy rooted in the people as a centerpiece of, although it was a monarchy, it was legit, and the people had mechanisms for removing a king who did not fulfill the objectives. Now, if you look at Ijebuland, the Ijebu system is a federation of kingdoms with Awujale as the senior king.
Yeah,
Yes, but you have a lot of kingdoms, and all of them have legitimacy rooted in the people. Okay, you go to the to Igbo land, for instance. Now, the Igbo system did not have chiefs, but it had an egalitarian system. And there are acephalous systems across Nigeria, like, it's not just the Igbo, the Luo, for instance, of Kenya, the same thing. It was very much rooted in the people. And you had the age grades, you had the titled people, they all met. And even in the bastardized post-colonial system that was created, what you had with the warrant chiefs were not hereditary. And so when a chief dies in Igbo land, the people elect their own chief. The community has structures for doing that. You go down to Southern Africa, it is not much different. So this idea somehow that, we do not have mechanisms, or mechanisms rooted in legitimacy with the people, are somewhat or somehow alien to our people is nonsensical, with profound respect. What's happened is people like President Obasanjo, and President Obasanjo, as good as some things that he did may have been, wanted to become a life president. The only reason he's doing saying some of this stuff is because he failed. Nigerians thwarted him in 2006 from succeeding himself. He wanted to amend the constitution and he failed. The reason he failed is very simple. Nigeria is too diverse for a life president. And the only thing that unites us as Nigerians, I like to say, is mutual loathing, right? So a mutual suspicion. The North does not want a Southerner to overstay their time, because it will be the issue, if the Southerner overstays his time, it is at the expense of the North. The Southerners don't want the Northerners to overstay their time in power. And so it creates a convention that somehow constrains a life presidency, which is why Nigeria's longest serving single-term leader or ruler was Yakubu Gowon, who served 9 years. So this is the point. I do not think, therefore, that I subscribe to what President Obasanjo has offered. I do think the abuse is from an elite that have basically circumscribed or actually subverted constitutional mechanisms of accountability in order to keep themselves and their families profiting from the commonwealth of Africans.
Interesting. Yeah. So sometimes back in one of our previous interviews, we're talking about Nigeria judiciary, and we're going to take a quick look at that before we go into other issues related to criminal justice. So my question on this is, in that past one of our past previous interviews, rather, I asked you that if there's going to be an overhaul of the judiciary system, say in Nigeria, that is there precedent in the continent? And I remember you said that, yes, Kenya did it, that they did this and that. Now, what happened in Kenya, that overhaul? Is it possible? Can it happen in Nigeria?
I will not say never, But it all depends on the circumstances. Obviously, every country is unique, and you cannot transpose Kenya into Nigeria and say, it has all the answers. Um, I do recognize the fact that, to begin with, judicial tenure is protected for life, for a long term in Nigeria, up to 70 years. And these days, what you're having in Nigeria is judicial insiders, senior judges and justices at the highest levels, planting their children um, who are in their early 30s, 32, 33, 34, and basically guaranteeing for these children judicial terms, tenures of over 35 years. And when you have that kind of tenure of somebody who is unsuitable, either in terms of skill, qualification, or temperament, or all of the above and more, for judicial office, what you do is create a toxicity in the system that you cannot eliminate so easily. The only way you can eliminate that is through disciplinary process. And if the disciplinary process has been compromised as well, then it is well nigh on impossible, which means you therefore need a political intervention to reset the judicial system. And in my view, actually, um, the only thing that can substantially address the dysfunctions, the entrenched dysfunctions in the Nigerian judicial system, and indeed in many of our countries now, is a political reset. And that reset needs to be grounded in popular demand. It needs to be grounded in demand from the people, and understanding that a system of judicial insiders by judicial insiders for judicial and political insiders cannot work and cannot deliver justice under any circumstance.
Interesting. So let me digress into another area, but it's similar to what I asked. I'm going to talk about the academia now, the university system, lecturers, and what have you. ASU has announced again that they want to go on strike. They need more money. It's looking like a perennial problem, go around like circumnavigating now. Now, don't you find it, as a lecturer yourself, someone that's been in the classroom, still in the classroom? I mean, you've spoken everywhere all over the world. We read what you write. And of course, you're homegrown Nigerian. Don't you find it ironic that these same lecturers during election will rig and enthrone these bad leaders, and they're now going back to them cap in hand to to beg for an increase? I mean, I've, does it mean the Nigeria academia has lost it totally? Or I'm in a confused state. That's why I'm asking you, because you're a lecturer too, and I know you talk to people that are in the system. So what's really happening? You help enthrone these people, educated people, PhD holders. You make 34 votes, 340 or 3,400. These guys come here and you go back to them begging captain. What's happening in the academia, Prof?
Now, I'm going to be careful how I handle this question. But I'll tell you why. I'll tell you. I currently chair the governing council of the Anambra State University.
Oh, okay.
And in that capacity, um, I have to be involved in the negotiations over the minimum wage, right?
Okay.
And that negotiation is with the university unions. That's the non-academic staff unions as well as academic staff unions. So I want to declare my interests here very clearly. Having said that, secondly, I don't. I also want to be clear that I don't want to. This is not about my personal views on university unions in Nigeria. The people who administer, whom INEC uses to administer these results, these crooked results in our elections, and I think you and I agree on that. It's it's a desperate advertisement of the shortcomings of the Nigerian university system, the ethical shortcomings of the Nigerian university system. Nearly all of those people are university vice chancellors.
True.
Right? True. Now, and vice chancellors, for the most part, are part of the problem of the university system in Nigeria. A university is actually a rule-constrained environment. Because in Nigeria, still, most university students are in the public universities. An overwhelming majority, over 80% of university students actually, are in the public universities because most people cannot afford the private universities and their fees. And the public universities are significantly subsidized. And therefore, most people, most families are able to send their children to the public universities, not the private universities. Now, every public university is established by law. The central problem, in my view, of the Nigerian university system is that most university vice chancellors have either not read the laws that establish their universities, or if they have read them, find those laws so inconvenient, they do not want to operate under them. As a result, no amount of money that you give to a university will work in a situation uh, in which the vice chancellors do not want to operate rule constraint systems. There are exceptions. I don't want to embarrass any university by naming names here, but there are some exceptions in which you see the vice chancellors actually do make an effort. And in those universities where the vice chancellors are making the effort to do things right under rules and to do that fairly, you see that the unions find ways to keep the universities going, notwithstanding any national action that may have happened. And this is really, I believe, what we need to address. It's clearly the case that at the national level, there are problems with education policy making, tertiary level, and indeed design, unquestionably so. But there's a great deal, implicit in your question is a suggestion that the universities also have to take considerable part of the problem, of the responsibility. And here, in my view, there is not much difference between what happens in the universities on the one hand and what's happening in the judiciary on the other hand. See, judges are complaining that they are badly paid, their conditions are hard. But when, as a judge, you collect money or collect other blandishments to hand over an election to someone whom you know lost the election, you have collected your retirement benefits upfront. You have collected your conditions of service upfront, and you cannot be heard to complain that you are poorly paid or you are not properly looked after. And it's the same thing. When, as a vice chancellor, you go to rig an election and announce results that a professor of mathematics, because elections are about counting, isn't it? And accounting. A professor of mathematics goes to announce results that he or she knows do not compute. The numbers don't add up. And the professor of mathematics will announce those numbers as having passed the rules of electoral arithmetic. The person simply has given up on any complaints about the university system. So this is unfortunately is what the case is. And again, we have a professor of history heading the INEC who is acting as if they are being blackmailed, or who is acting as if they've made themselves subject to blackmail, because what INEC is doing cannot be explained rationally. You lay out rules, you lay out standards, you subvert the same standards, you operate against the same standards, and you organize elections in which you produce 2-3 different results, sets of results for the same election. So in Edo State, the results on the IREV are different from the results that INEC has announced. And it looks like some of the results, at least, that they are certifying are different from the results that they announced, different from the results on the IREV. How do you do that for one election? Announced, by the way, by professors. So at some level, this whole thing defies any understanding or any explanation.
Interesting. You see, there's a reason I wanted us to talk about the judiciary. Now we're talking about the academic class. Let me ask you about the law enforcement now. I mean, I read something you wrote recently, and I'm sure a lot of people have not read it, but I just want to ask you about it. And this could be an opportunity for you to talk about it. It was Egbetokun Lokon, which means Egbetokun is next, and that Lokon came about from when Tinubu said, the current president of Nigeria said, Milokon, that means I'm next to the president. So when you title the Egbetokun Lokon, that Egbetokun is next. I mean, is it, what exactly are you saying that now that it's clear that the judiciary, the academia is more or less compromised, does it mean that the law enforcement, which is police, is now permanently in cahoot with the level of compromise, or it's just the Egbetokun that is a bone of contention?
Well, Egberto Loka is exactly what it is. It is now his turn, right? and and you see, as I say in that article, in 2009, Kaide Fayemi, who is the immediate past governor of Ekiti State and a visiting professor of war studies at King's College now in London, flew to Louisiana, New Orleans, to address the African Studies Association. And he spoke about the 5 gods that need to be satisfied in order for you to win an election in Nigeria. And among those, he listed those 5 gods with a small g. INEC, number 1. The security services, particularly the police, number 2. Thugs and bandits, number 3. The judiciary, number 4. And the money god, number 5. And then he spoke about the Godfather complex. Now, you need to look at this hierarchy or this list of gods, right? At the center, number 3 is thugs and bandits, right? On either side of thugs and bandits, you have police and judiciary. Correct?
Absolutely.
This is I can send you Dr. Fayemi's address. Okay?
You'll be my guest sometime soon.
Now, so this is exactly what I do say in this piece effectively is that at that time, Dr. Fayemi was complaining, saying this arrangement threatened Nigeria's democratic system, which at that time was barely 10 years old. What I'm saying now is the way that Dr. Gbetokun is going about his job as the Inspector General of Police, he has converted Dr. Fayemi's bleak prognosis into a manual of policing. So, and he now has this alliance with thugs and bandits and some crooked judges. And basically, he is using the authority of the Inspector General of Police to enable thugs and bandits on the artifice of doing what the judges, some crooked judges, have told him to do. This basically is what has happened. Whether you're looking at Rivers State, where there were 2 court orders that conflicted with one of them with one another from the same court system, from coordinate court systems, High Court of Rivers State and Federal High Court. He did not even, and he was served with the order of the Rivers State High Court. He did not even acknowledge it. He went in and claimed he was obeying the order of the Federal High Court, which contradicted the order of the Rivers State High Court. And then, after the people were sworn in the election, or rather on the election day, claiming that he was enforcing the order of the Federal High Court, police officers went around destroying ballot boxes, destroying voting rolls. And the following day, after the supposed winners were sworn in, what did he do? He said he was withdrawing police assets from the police stations. And it seemed quite clear, the Yoruba have the proverb, don't they? That, if the witch cries at night and the baby dies in the morning, you do your own arithmetic. So the Inspector General of Police, who, by the way, is Yoruba from Ogun State, withdrew the police. Thugs moved in and started burning local government headquarters, one after the other. And the president issues a statement from wherever he is supposed to be, somewhere in the world. And what he did not say was the most important thing. In no place in that statement by the president did he say, I have ordered an investigation into this and a report will be delivered within this time frame, and whoever is implicated in this will be brought to account in accordance with law. The president, that was too much for the president to say. Yes? At the same time that he was supposedly obeying a court order in Rivers State. The police assets under the command of the same Inspector General were making sure that a court order to inspect election materials in neighboring Edo State was frustrated. And they didn't just frustrate it, precluding the enforcement of that order. They went further. They invited thugs to break up the enforcement of that order. I could go on, see what they're doing with the children and young people who organize the End Bad Governance protests and charging them with treason. The only senior advocate of Nigeria in Nigeria who is in the police service, in the police force, is the person being used to prosecute young protesters for treason under the watch of this Inspector General. And it seems quite clear to me that what is happening is that this Inspector General has his fealty not to the law, not to the country, not to the institutions, and certainly not to the people, but to his patron, whom he has served for a very long time as ADC. So instead of being Inspector General of Nigeria, he's ADC General of Nigeria. That is tragic. That is dangerous.
Wow, now we get it. Like I said earlier, we discussed the judiciary, the academia, law enforcement. Let's talk about political leadership now. And I want to talk about especially what's been happening in Rivers State, which also has something to do with the current Inspector General of Police. We've seen Wike versus Amechi, Wike versus Tambuwa, Wike versus Dave Umahi, Secondos, Wike Gajabe, Wike fighting everybody. I can go on and on. Wike versus Akpabio, Wike Ali Modu Sherif, Saraki, Wike Oshomole, Wike Jonathan, Wike is now Wike Sim Fubara. So I mean, Wike, I'm calling his name because he's a life venture. I think he's a lawyer and all that. So now my question is, why is the NBA lukewarm to recalcitrant lawyers who are obviously trying to truncate democracy, in my opinion, in our opinion? Because something we've discussed here a lot. I'm like, why is the NBA, it's bad enough the judiciary is the way it is, but the NBA as the body of lawyers sees these things. I see some son. There's a guy, I can't remember his name. It's from Kogi State. He writes the right things.
Jibrin Okutekpa.
Okutekpa, yeah. He says fantastic things, I've seen even the current Attorney General say something supposedly politically correct. But what's happening? Is it that the NBA cannot rein in these guys? Or is it fair to say the NBA too has gone kaput?
Well, look, in Nigeria, as in many other African countries, it's not just in Nigeria, we've created a system in which rich, powerful people are beyond the law. They are granted impunity. Nyesom Wike was chief of staff to the governor of Rivers State. It was local government chairman, chief of staff to the governor of Rivers State, and then minister of education, governor of Rivers State, and now minister of the Federal Capital Territory. As I like to suggest, he is godfather. He wants to be godfather general of Rivers State politics and of the PDP. And it looks like he's a member of both the PDP and the APC at the same time. And certainly he's paddling both boats, 1 foot in one and 1 foot in the other. And his wife is a justice of the Court of Appeal. His sister-in-law, I believe, is a judge of the High Court of the FCT. He's a life bencher, so he's also a senior insider it's part of this pattern of insider dealing in judicial appointments that makes it impossible for the kinds of of impartial decisions that we expect from the judiciary to occur. And given all of that, it's not at all an accident that this would happen. Don't forget, it was Wike as governor of Rivers State whom the Chief Justice of Nigeria visited in November 2022 to commend the so-called G5 governors who were members of the PDP, who at that time had split out of the PDP in support, supposedly, of the idea of a southern president. And it was Wike who hosted that. and the Chief Justice went there to do that extraordinary faux pas. Now, so there's a great deal of insider dealing that makes it, and then it was the same Chief Justice who subsequently elevated, as the chairperson of the NJC, who subsequently elevated Wike's wife to the Court of Appeal, and who also supervised the appointment of the sister-in-law as a judge of the FCT, of the High Court of the Federal Capital Territory. So this network of mutual incest really accounts for what you have seen and what you're describing. It's nothing more than that. At the end of the day, the NBA needs to make money in order to run its affairs, and if you can get donations from the Minister for the Federal Capital Territory, why not? And when you think about it, there are only about 3 locations these days in Nigeria that can realistically host encounters, meetings of the NBA. Lagos, which has just hosted the last meeting, Abuja, which hosted the meeting before that, and Port Harcourt, which will host the meeting next year. There are no other locations in Nigeria that these days host annual conferences of the Nigerian Bar Association. And when the NBA meets in these places, they require political patronage. And if you're the minister for the FCT, or the governor of Rivers State, or the governor of Lagos State, you have a huge leverage on the NBA, sadly.
Oh, wow. That's very sad. So that leads me to the next question. We've looked at the judiciary, we started with the Malabo Protocol, and there's a reason I wanted you to talk about that, and of course, going to the criminal justice system in Africa overall, it doesn't look like well with the continent, at least majority of it. And it's clear that most of the countries that have not ratified or even signed the protocol is for obvious reasons, because signing it will make some of their leaders maybe likely to be arrested or something. So now that pushes me to ask you this: okay, the police security system is not working. It does, like I asked you, is it a biometric? No, it's not just a biometric. It's the norm. Like we refer to Kayode Fayemi's initial statement sometime back, and it's coming to fore that the police is not functioning. The judiciary system is not functioning. The political class lacks whatever it takes because of the corruption in the system. The academia itself is almost non-existent. And we keep asking where are the leaders in the room? The leaders in the room are supposed to be amongst all these people, and they're really non-existent. So if we narrow it down to the Nigerian scenario, is it not fair to call Nigeria a failed state, considering that the major insignia for a failed state encompasses all these 4 areas I'm talking about: judiciary failed, academia failed, police failed, and of course, clear failure of leadership. Because if the academia is not working, the educational system automatically doesn't work. And if there's failure of leadership, the political leadership would not provide water and the basic amenities. And from what we see today, the largest population of Black people in the world is not functioning, not in any way or form. The ship of state is almost clearly rudderless. So is it fair to call Nigeria first?
Well, let me start with the Malabo Protocol and make a clarification. 2 things. One of the criticisms against the Malabo Protocol is the immunity provision in Article 46A bis of the protocol. And it precludes specifically, explicitly from the jurisdiction, personal jurisdiction of the court. The court created is called the African Court of Justice and Human and People's Rights. The African Court of Justice and Human and People's Rights is a bit of a mouthful, but that court will not have jurisdiction over serving presidents and, in all likelihood, foreign ministers. That's clear on the text, on the face of the text at the moment. And a lot of people are complaining that that means it's going to be limited and it's not going to be worth it. But I say this because of your point about most of the heads of state will be caught up in it. While they are serving, they will not be subject to the jurisdiction of the court. They can only be subject to the jurisdiction of the court if they have left office. Yeah, so it's not substantive immunity, it's a procedural immunity, and it's a temporary immunity. Now, my response to that point, of course, is I think that's really it's a lot of froth that really goes to nothing. It's only African heads of state that have ever been arrested or been presented before the ICC. The Kenyan president, of course, Uhuru Kenyatta, and his deputy, who is the current, who was Uhuru's deputy, did accept to go before the International Criminal Court in a trial that eventually failed. President Bozizé in Central African Republic has gone before the International Criminal Court. Of course, you had Laurent Gbagbo from Cote d'Ivoire, and Jean-Pierre Bemba, the former vice president of DRC, also was there. Charles Taylor has been convicted as former president of Liberia. Of course, the AU did set up a specific trial for Hissène Habré in Chad, and he was convicted. So the one thing you can actually say about the African continent is that we've seen it all, and after the African Union has shown that Africa can actually bring to account, for international crimes, African heads of state, or former African heads of state. And African heads of state have voluntarily also subjected themselves to the ICC. No other heads of state in any other part of the world have done so. Yeah. Now, so this is, but the fact of the matter is that if a head of state can win an election, you are not going to subject them to trial. True. You're not going to go to arrest them. And many people still believe that the ICC indictment in Kenya was instrumental in Uhuru Kenyatta's re-election, certainly, if not indeed his original election, because the Uhuru basically chose to run against the ICC. Sorry, chose to run against the ICC. Essentially, his campaign was against the ICC, and he won. He made his election a referendum on the ICC process. Now, and when the second point about that is a court that has not even proved that it can bring ordinary suspects to trial should not go after a head of state, because heads of state have resources at their disposal, not to speak about political goodwill at their disposal, that the 200,000 million euros of the ICC cannot match. In Kenya, a lot of the witnesses who were involved or who were supposed to testify in the proceedings involving the leadership of the country disappeared. Many of them died. Many of them, their bodies will never be found, because the presidents have the wherewithal to make it impossible for these people to live their lives. A lot of the Western countries where people froth at the mouth and tell you that they are going to, heads of state should be brought to account, will not host these people as exiles. I personally was involved in putting together the case in Sudan. When Luis Moreno Ocampo, who was then the prosecutor of the ICC, decided he was going to go after the president of Sudan, I flew to The Hague to meet with Ocampo in his bedroom to explain to him the implications of doing that, and that they were going to be endangering the people whom we had worked with to build the case. All he could tell us was if we could find an African country to hold them, they could give us money so that Africa can keep those people. Every one of those persons, bar none, had to be exiled from Sudan as a result of that, the silliness, in my view, very unconsidered decision of the prosecutor of the ICC. Every one of them, two of them eventually died in circumstances that I still find difficult to deal with till today. And they died after agents of the state picked them up and did to them what should not happen to any other person. Oh, wow. Okay? So when these people talk about holding heads of state to account, I laugh at them because they will not do the things that are required to bring heads of state to account. And so it's irresponsible, in my view. A lot of these people who open their mouth to talk about responsibility of heads of state and why why the African Court Malabo Protocol is this and that, I think they're very responsible people. They will not follow up the obligations that come with doing that. Now, so that's the first clarification I want to make, that the Malabo Protocol actually does not go after serving heads of state. And in my view and experience, there is good reason for that. They, having said that, the court also needs to prove itself when it comes into being, that it can actually bring to account lower level perpetrators, which is really where the problem is, that lower level perpetrators get support and cover from higher level people. If you can bring to account the lower level perpetrators, then over time, it will be possible to develop the muscle, the institutional muscle with which to go after senior people and heads of state. Now, so returning to the question, therefore, of continental justice systems and what to do with them, I will tell you the truth. This is the current evolution of my thinking. I think we became independent with intellectual laziness. So we were told at independence, oh, we inherited independent judicial systems. Yes? Our courts were independent, if you're in Nigeria in 1960, in Kenya in 1963, in Mauritius 1968, and those kinds of things, right? But that's a lie. Or in Zimbabwe in 1980. That is an absolute lie. You know why? You cannot talk of colonialism and independent institutions in one sentence. Colonialism did not produce independent institutions. Colonialism did not give people the skills or the habits to run independent institutions. The jurisprudence is there to prove it, but if you just step back and listen to what I just said, it is so self-evident. So our students are taught a lie. We are taught in constitutional law, administrative law, the legal system, in all the colonial, post-colonial states that there were independent systems post-colony. There weren't. And so the political leadership and redesign skills required to establish independent systems, we did not try to cultivate. Instead, under the doctrinal mistake that we had independent institutions, we looked away while our politicians did what they knew how best to do. Collect those independent institutions and put it, supposedly independent institutions, which were not independent, and put in their pockets exactly the same way that the colonialists did. So the institutional redesign we needed to do post-colony failed, did not happen. And that is really now what we need to address. So I wouldn't go as far as saying there is a failed state. I'm saying now we need to address the project of establishing independent institutions. That is a political project. It is not going to be governed by the professional incest. So, we are talking about independent judicial system. So let's invite the Bar Association, invite the judges to deal with it. No, it is not for the judges and the lawyers to do. Establishing independent institutions is for citizens. That is political. And that is why I talk about political reset. So this actually requires us to go back to base zero and undertake the epistemic journeys required to build countries with institutions that work. So rather than say we are a failed state, I actually would say now the project of state building has to begin.
Interesting. Let me ask you this before I ask you my final question. Is there a country in Africa today that you can say, after all said and done, politically, they are doing the right thing? When you look at their judiciary, the police, and everything, is there any country worthy of emulation, or two or three possibly?
Every country is work in progress. I mean, look at the United States. Look at the United States Supreme Court, for instance, right? That's a democracy that is over 200 years old. Nobody would say the US is not a democracy. In 2020, the United States faced a stress test to its democracy and by and large came through, even if with scars and injuries, but it came through. And now in 2024, it's going to face another test to its democracy. Now, so every country is work in progress. And therefore, and African countries which are very recent, where the Egyptian revolution took place in 1952. Sudan became independent in 1956 with Tunisia. Ghana 1957, Guinea 1959. These, by and large, are recent events in human history, over the course of human history. We're talking about a lot of people who saw those things are still alive today to tell the stories of what transpired. So I think we also need to step back and understand we are dealing with things with a timeline that is actually not that vast. That's not to say that we must repeat the mistakes of the United Kingdom from 1689 or things like that, or the United States from the 19th century. No, we should also be able to learn from those and do better. So having said that, other African countries, well, you could say Mauritius is actually not doing terribly in terms of its own institutions. The Seychelles, which has borrowed judges from different countries to be able to build its systems, has been working to some extent. By the way, Cape Verde has not really had a coup in the sense of many of our countries. And at least Cape Verde has managed to build. Sorry, Senegal has not exactly had a coup, and Cape Verde system. Now you say I'm talking about islands around Africa. What about the African mainland? Now, and on the African mainland again, Kenya. I think we've got to say with reference to what happened in 2010. In the 2010 Constitution of Kenya, is actually come a very long way, and Kenya's reform of its institutions and its constitutional system took over 3 decades to come to fruition in 2010. And the Kenyan judicial system is being tested and is being proved by and large with tremendous challenge to come through some of the tests in a decent manner. Botswana used to get its judges, by the way, from Nigeria. Akinolagoda, who came from Ondo State, used to be president of the Court of Appeal of Botswana. The first indigenous Chief Justice of Botswana was Moleleki Mukama, who succeeded Akinolagoda actually in the 1990s, I believe 1992, 93, right? Now, and Botswana today is producing judges of tremendous quality. Now, yes, the BDP has been the party in power since Botswana became independent in the late 1960s, but the Botswana judiciary is holding its own. Namibia is also not doing badly in terms of the performance of many of its institutions, independent institutions of accountability. So there are models that show us what is possible. Benin Republic, until recently, also did actually have one of the better judiciaries in the civil law systems in Africa. And despite challenges, that judiciary is still holding its own for the most part. So I do think that we do have possibilities on the continent. Now, are there also terrible situations? I do think so. Nigeria is doing very badly. Uganda is doing quite badly, in my view, when it comes to judicial institutions and the independence, the building of institutions that can be considered capable of holding the government to account. I think Nigeria and Uganda and Zimbabwe is also doing terribly. I think Zimbabwe, Nigeria, and Uganda are three of the most difficult, challenged situations when it comes to independent institutions for accountability.
Wow. Any hope for, let's look at Nigeria quickly before we go. In lieu of all this poor election, bad judiciary, police, academic, everything seems bad. Is there light at the end of the tunnel?
Yes.
Well, there is light. Why
Well, I wouldn't be doing what I do if I thought, Nigeria is going to collapse tomorrow.
like
Nigeria is going to suffer the fate of the Titanic. You don't even bother about rearranging the deck chairs, just flee. No. And I think we have a duty to sow hope. Let me go back to Kaide Fahimi's um, address to the African Studies Association in 2009. I believe when he was speaking, he was very convinced and very honest. And yet, 6 years later, the PDP was toppled in a vote. And in my lifetime, 2015, 2006, many people believed Obasanjo could change the constitution and do whatever he wanted. 2006 happened, he was rebuffed. Correct?
Correct. Yeah.
1998, most people believed Abacha was going to succeed himself. In 1998, Abacha died. Howsoever he died, Abacha all of a sudden died, and Nigeria all of a sudden had a chance to retool. In 1993, very few people believed that it was possible to change, to get a candidate who could reach the spread that Abiola reached. And indeed, if you read Tony Aneni's autobiography, My Life, Aneni tells the story that the reason the military, and Aneni, of course, was in cahoots with, he was briefed by the military. And he said, this is what they told him. Aneni said that the military told him that they expected Bashir Tofa to win. That was the intelligence briefing. And they expected Tofa to win because Tofa was not a member of the NRC. His registration card as a member of the NRC actually belonged to a woman. And they had evidence of that. So the military was banking on Tofa winning, and then they're using that to nullify his election and staying in power.
Oh, wow.
They never banked. This is written down, okay? Yeah, I'm not making this up.
I'm going to buy the book.
Now, they did not bank on Abiola winning. And Abiola did not just win. He won overwhelmingly, 58% of the vote. Even the intelligence services did not pick that up. The security services under Haliru Akilu for Babangida did not pick that up. Now, this is the point. So Nigeria has managed in many ways to defy a lot of its detractors. At the moment, we do have a concatenation, a coincidence of a lot of things. Mismanagement of the economy by an administration, in my view, made up of people who don't care about the people and who have a grave legitimacy deficit, and who are therefore destroying institutions in order to hold on to power in defiance of their legitimacy deficit and in defiance of the people. All of that is there, and it's looking like there is no way out. But you see, in the energies of the young people who are organizing the demonstrations, who are defying the will and of all of these people, you see that there are possibilities for the country. And every one of us, irrespective of these challenges, wherever we may be, we have a duty to support in some way these young people, to give them hope that it's going to be possible for them to reclaim and retool our country, their country. Because if we don't, a Nigeria that goes belly up is a security crisis for all of Africa. It's not just for Nigerians. If the country goes belly up, where are these young people going to go? Benin Republic cannot contain them. Cameroon cannot contain them. Chad cannot contain them. Equatorial Guinea will not contain them. Europe will not have space for them. But so a lot of Nigerians will be dying in the Straits of Gibraltar, drowning in the Mediterranean. We have a responsibility, therefore, to foster hope and allow their imagination to fix problems from the country that does not at the moment appear to care for them. This is what gives me hope. Not that we have any ready-made solutions, but that in the frustrations that these politicians are creating, our young people are going to invent solutions that we have not even thought about.
Fantastic. Thank you, Professor Chidi Asamodeka Vintage. Fantastic. You always rise up to the occasion. And to our listeners and viewers, wherever it may be, it's going to be a wrap there. Prof, thank you for coming to Atlanta Discuss. Thank you.
Thanks. Thanks for having me, and thanks for what you do, my brother. May the heavens keep you. And happy birthday. Happy. Welcome to the 5th level. You see how exciting it is.
It is. Nothing to lose anymore.
Thank you.
Thank you. So, all right, sir. That's it there. We'll see you next Friday. We'll discuss it. You know what the Malabo protocol is. You know the state of the justice system in Nigeria, in Africa, in Ghana, Kenya, whatever. But we all have a duty. It looks like it's very bleak and dark, but historically it has shown that when it looks that bad, something is always about to give. Never lose hope. There's history to show that we're on the verge of something. What it is, I don't know, but let's keep the flag flying. Prof, thank you once again for coming. Bye.
Thank you very much.
See you next week.
Okay.